I just wanted an explanatory note on the food situation. We didn't have coffee, I'm told, at this break because we're having a reception in the foyer after this session. So those of you, particularly those who kindly flew in from all over the place who need coffee, it will be here in about an hour. So there you have it. It's a particular pleasure for me to chair the last panel today, specifically because it has several people presenting who have been very influential to my career over the years. Both Professor Davison and Professor Leifer, in different capacities, have really been a very big influence on my career. They and Professor Westcamp will be speaking about the database protection debate, which really came to the international fore in the WIPO copyright treaties in 1996. The first speaker is Professor Davison. He is a Professor of Law and he's the Associate Dean of Undergraduate Studies at Monash Law School in Australia. And he is an ex-colleague of mine and, in fact, the supervisor of my LLM thesis, so I can share your feelings from the first panel with having an ex-supervisor speaking. Professor Davison is a leading expert in pretty much everything: copyright, trademark, unfair competition, antitrust, which we call restrictive trade practices in Australia. I'm very familiar with his work and it's been very influential. He's a co-author of the latest edition of Shanahan's Australian Law of Trademarks and Passing Off. He has written I think the first textbook devoted solely to the database protection debate, published by Cambridge University Press a couple of years ago. So with all of that, I'll turn it over to you.
First of all, I'd like to record my thanks to Jackie for inviting me here. Secondly, the reason I'm down here is that since you brought me all the way from Australia, it's only reasonable you have an opportunity to see me. And I think if I sit there, you've got Buckley's of seeing me. So it's a good idea that I stand out here. It's a strange topic to talk about databases in this context because, of course, as you know, there is no treaty on the protection of databases. It was suggested in 1996, but it's gone nowhere. It's taken WIPO 10 years to do nothing, and it's taken the US the same period of time to do the same, namely nothing. But I would say that it's been really hard work. It's been incredibly hard work to do nothing for 10 years. And WIPO and the United States should be congratulated for doing nothing for 10 years and working so hard at it. And I'd contrast that with the EU, which in one sense has done a lot. The outcomes in relation to database protection in the EU are quite significant. But I think they've been very lazy about the way in which they did it. And I want to share with you a little story which I think exemplifies getting a lot done but being really lazy about it. The EU put to the WIPO conference in 1996 the idea of a database treaty, which was based on their directive. It was, by and large, a photocopy of the directive, and they said, why don't we have this as a treaty? And they then ran with that idea at WIPO for several years, and at several of the meetings of the Standing Committee on Copyright and Related Rights, they said things like, and it's in my paper, the experience of the directive has been very positive, and we would be glad to share that with delegates. Now, in 2001, I'd promised the Australian government in return for, airfare and bus fare and a night in a youth hostel to find out what was the impact of the EU directive. And I thought, gee, they've gone all the way to WIPO and said it's a positive experience. They must have some real evidence of this. I've got to get to Brussels and find out what the deal is. So I went to Brussels, and I was a bit like a short Aussie version of Gomer Pyle, because I was sort of going, golly, this really is an important place, shucks, and all that. And I was a little intimidated. This was the seat of power of possibly the biggest economic force on the planet. And I must say I was treated with great courtesy and respect by EU officials who were kind enough to see me. And I had a conversation with one of the officials who was closely involved in the implementation of the directive. And it was a very useful conversation, and I'm exceedingly grateful for it. But towards the end of it, I thought, well, here's my chance. I'm going to ask the question. Tell me about these positive experiences. Where is the evidence that this directive has been terrific? And there was a slight pause in the conversation, and he looked at me and he said, after the transposing legislation came into effect in 1998, during some of my lunch hours, I went into nearby department stores and I noticed that there were a lot more CDs with databases being sold. And I was going, yeah, well, where's the evidence that the directive has been positive? That was it. Here we are, international treaty. The whole world has to think about, talk about an international treaty on the protection of databases, and it seemed as if that was the extent of the evidence. And that was the basis upon which the EU was saying, at WIPO, it's been a very positive experience. So soon after that, I picked my jaw up from the floor, where it had fallen, and I bade my farewells. Now that's an example, I think, of the EU just being a little bit lazy, but achieving a lot, because what they got was the whole world talking about database protection for a very long period of time on the basis of some very flimsy evidence. And they've now worked out that, in fact, it was exceedingly flimsy evidence, and their directive has, by and large, been a waste of time. Now, the EU had two objectives with its database directive. The first was to harmonise protection for databases throughout Europe, or the EU, and the second one was to increase the production of databases in the European Union. Their view was that they'd found themselves a weapon of mass production that was going to lead to them catching up with the US in relation to databases. Neither of those objectives has been achieved. In relation to harmonisation, the way in which they did it was to harmonise the standard of protection under copyright for databases to a Feist standard, and I won't go into the Feist standard here. I assume you're familiar with it, but in any event, I'm more focused on the second thing that the directive did, and that was to introduce a new so-called sui generis right to protect databases. Now, it's called a new right, but as a common law lawyer, as a common law copyright lawyer, when I looked at it, I thought, that's just sweat of the brow copyright. And if you look at the subject matter, which says a database in relation to which a substantial investment has been made, either qualitatively or quantitatively, in obtaining, verifying or presenting the information or the contents of the database, that's the subject matter that gets protected. Now to me, that's sweat of the brow copyright. You've done gone to a lot of effort to create a database. That's called sweat of the brow. Then I looked at the rights which are conferred on this subject matter, and I saw that there were new words: extraction and reutilisation. They're not in any of the copyright treaties. This is different. Until you go and look at the definition of extraction and reutilisation. And the definition of extraction is really the reproduction and copying rights that copyright lawyers are very familiar with. And reutilisation, well, it's basically making available, either in hard copy or via transmission. So the subject matter is the same, the rights are the same. What about infringement? Well, infringement is if you take a substantial part, or should I say extract or reutilise, a substantial part of the contents of the database, whether measured quantitatively or qualitatively, you infringe. I'm going, substantial part, copyright. How do you define substantial part? Quantitatively or qualitatively? Copyright. So I'm thinking, this is copyright. I think the English thought that too, because they just put the Database Directive or the transposing legislation in the regulations to their Copyright Act. They just thought it was another bit of copyright and just chuck it in. But there are some very significant differences between the directive and copyright, or this sui generis right and sweat of the brow copyright. The first one is the duration of protection. Under copyright, it's basically life plus 70. Under the Database Directive, it's either 15 years or eternity, depending on which one lasts the longer. And the reason for that is that in theory it's 15 years, but if you make a substantial investment in updating it, which includes verifying the contents or the accuracy of the contents of the database, the period of 15 years starts to run again. So as long as you keep updating your database, you will have protection in perpetuity. So that's one difference between that and copyright. A second one related to the exceptions or the lack of exceptions. So, for example, there's no exception in relation to reporting the news, which is basically ubiquitous throughout copyright legislation throughout the world. None at all. There's a very limited exception which reads extraction for the purposes of illustration for teaching or scientific research. And that's one, very narrow, and two, a little bit ambiguous, because is it illustration for teaching and illustration for scientific research, or illustration for teaching or scientific research? Don't know. So I said to the British Copyright Office when I was in London, which is it? And they said, we don't know. So what did you do? Oh, we just photocopied that bit of the directive and chucked it in there, and we'll see what the courts do with it. The Irish and the Italians had a different approach. They just forgot about it. They just didn't put it in their legislation. So much for harmonisation. You have a very limited exception and then you don't require everybody to have it anyway. So harmonisation starts to go out the window. There's another aspect of infringement which makes it, I think, different from copyright as well, because when it comes to infringement, it says that a qualitatively substantial part of the contents could be extracted or reutilised. Now, that then, to me, raises the possibility that someone will say, that bit of information there, that datum, is qualitatively important. It costs us a lot of money to get it. You copy it, you extract it or reutilise it, we win. So that, I think, is different from sweat of the brow, which would suggest that if what you're protecting is sweat of the brow, it has to be a fair bit quantitatively that's taken in order for there to be infringement. So there are some differences between the database right and copyright. And I think the major difference emerged as a consequence of the ECJ decisions on the meaning of the Database Directive. Now, in the discussions about the directive and how it would be applied, there was much talk about limitation on access to scientific information, and there was considerable concern about that, and there still is. But the important case law that went to the ECJ was about things that are far more important than science. We're talking gambling and sport. These were the key issues that were litigated in the ECJ, and there were 4 cases that went to the ECJ, and basically they were about the copying of football fixtures, you know, Liverpool versus Arsenal at Highbury on such and such a date, etc., etc. And they were being copied by gambling organisations so their customers could bet on the outcomes of the games. There was an English case also in relation to the British Horse Racing Board, which had and has a very extensive database of information about horse races in Britain. And again, a gambling organisation, William Hill, had extracted and reutilised a fair amount of the data. I won't say a substantial part, because that wasn't the finding of the ECJ. Now, that went to the ECJ, those cases. And it needed to go to the ECJ because on this issue of harmonisation, what had happened was that the English had done their thing, which was, yeah, that's sweat of the brow copyright, we know that, no problem. The Scandinavians said, no, that's our catalogue laws, which we've had for ages. We know that. And in fact, when I was doing my research on this, I arranged for someone to translate the Swedish law for me because I couldn't find an English copy of it. And I gave what I thought was the Swedish Act to the interpreter, the translator, and I gave him also an English copy of the directive. And I said, look, I'm pretty sure that this legislation is going to look a lot like that because that's what directives are for, okay? And he said, yeah, fine, terrific. He rang me back the next day and he said, is this supposed to be about databases? I said, yes. The word database isn't there, or the Swedish word for database isn't there, and it's about 2 paragraphs long. And I said, well, you know, there's 3 options here. A, I've got the wrong piece of legislation, which is possible since I don't speak Swedish. B, you're not very good at Swedish. C, the Swedes are anarchists when it comes to the Database Directive. And for a whole bunch of reasons, I'm pleased to say that it's C. Basically, the Swedes just changed the period of duration from 10 years, which was the duration for protection of their catalogue, under their catalogue laws, to 15 years. Basically left it at that, which seems fairly reasonable. So the Brits thought they had it right. The Scandinavians thought they had it right. The French said, well, actually, we've got unfair competition laws, and they came up with one case where they said, no, you lose, you don't have a database right here, but you win on our pre-existing unfair competition laws anyway, so don't worry about it. So there needed to be some harmonisation of the meaning of the database right. And in relation to those 4 cases I mentioned, 3 about football fixtures and 1 about the British Horse Racing Board's database, the ECJ said, you've got to look very carefully at the wording. The wording is about whether there's a substantial investment in obtaining information, not creating information. And it made that distinction very clearly, and it said, football fixtures, you create them. You decide that Arsenal's going to play Chelsea on the 3rd of March at Highbury. You create it. So you're not within the subject matter of the database right. Same with the British Horse Racing Board. You've created all that information about which horses are running at Epsom on such and such a date and who the jockey is and all that sort of stuff. You created it. And by so doing, the ECJ has diminished the scope of the directive quite considerably. In particular, it's made it more difficult for what Bernd Hugenholtz would call those who have synthetic information, people who've made that information or created that information, and therefore, by definition, are the ones who control it. Because they made it, it's impossible to get it from any other source. It's only the English Premier League that can tell you when Arsenal and Chelsea are going to play, because they decide when Arsenal and Chelsea are going to play. So there was much jubilation amongst those opposed to the directive as a consequence of those decisions. But I think there are a few problems with it. The first is that I think European courts are going to have a very hard time distinguishing between creating information and obtaining it. When it comes to sweat-of-the-brow copyright cases, in common law jurisdictions, basically the courts gave up. They said, can't pick it, you win. And they handed over copyright protection. And there are scenarios you can think of, for example, DNA sequences. Does that information exist and you just collect it or obtain it, or do you create it? Because there's deoxyribonucleic acid, I always wanted to say that, and it has a particular sequence, but until you actually find out what that sequence is and write it down, that data doesn't exist. The acid does, but the data doesn't. And there are all sorts of other circumstances where it's going to be very difficult to distinguish between those 2 situations. The other problem is that any sensible database owner is going to think very carefully about how to get around the decisions. And one of them is that you can still get a database right even though you've created the information, provided you make a substantial investment in presenting it or verifying it. Now, what will happen, I think, is that people will set up their systems so they can say, here is the investment I made in creating the information. Then I verified it. Then I presented it. And provided you've made a substantial investment at the verification and or presentation stage, you win. And what you win is not rights in relation to your investment in verification and presentation. You win rights in relation to the contents, because the infringement test is you cannot take a substantial part, or extract or reutilise, a substantial part of the contents. So that's the first thing people will do. They'll arrange their affairs so that they will in fact get their database right. The other possibility is, I'll create the information, then I'll sell it to you. I created it, you obtained it, you paid me for it. Congratulations, you have a database right. By the way, would you like to sell it back to me? Then I'll get back the database right that you've got as a consequence of buying the information off me in the first place. There will be games that will be played in order to get around this problem. So it's a tricky proposition in a technical sense, the directive, as to what exactly it means, how it will operate and so on. But the real problem is, don't worry about the technical bits, it's been a disaster. Right? It was introduced because it was supposed to be the weapon of mass production, which Europe wanted to proliferate throughout the world via a treaty. Well, they have written their own report on it and they've said, oh, whoops, it's not. They looked at another database called the Gale Directory of Databases, which has lists of databases in various places, and they worked out that according to that, which is limited information, but a bit better than something to do during your lunch hour, I guess, they worked out that in fact the United States has pulled even further away in the production of databases at a time when the US has not had any sui generis legislation for the protection of databases, and it has a Feistian copyright standard for originality. And basically they're going, oh, whoops, we haven't achieved anything here. Well, they have. They've created a new right, enormous transaction costs, and wasted a lot of people's time. I mean, I went to Brussels for a start, and frankly, you know, it was a nice city, but I could have stayed home and done other things. But there are enormous transaction costs in that everyone dealing with a compilation of data has had to deal with issues of both copyright and this database right. The transaction costs associated with this are very significant. And what's more is it very nearly became US law, because as soon as the EU adopted the directive in 1996, a very similar piece of legislation was put before the American Congress in 1996, which was basically a photocopy of the directive, except that they increased the term of protection to 25 years, which, as I pointed out before, is irrelevant because it was perpetual anyway. Now, lying in wait, though, were the academic communities and the science communities in the United States. And they were tapped into Congress and the Commerce Committee, and that legislation was strongly opposed. Now, since then, a whole bunch of other pieces of legislation have been put before Congress, which have progressively and decreasingly suggested a database right which is far less strong than the exclusive property right in the European directive. To the point where in 2004, which as I understand is the last time legislation was put together, basically it was a legislation which was relying upon very much the decision in the Motorola case about time-sensitive information. And even that got knocked back because in the Motorola case, the court said highly time-sensitive, and this legislation said time-sensitive. So the Commerce Committee again was saying, you can't have that. Tell you what you can have, you can photocopy the decision in Motorola and you can have that protection, which is exceedingly limited, and as far as I can work out, it's only been applied positively for a plaintiff once since the decision in about 1998. So that's the position that we've got to. Now, you should also know that in 1998, the second piece of legislation passed the House of Representatives, and it went within, or would have gone within, a few votes in the Senate, but for, as I understand it, the direct intervention of the then Vice President. So in fact, the United States went that close to having legislation which would have been quite similar to the EU directive. Quite similar indeed. And if the EU had got it, and the US had got it, you'd better believe that everybody else would have got it, on the basis of what we've already been told so far today by other speakers. And so the world went that close to having this so-called weapon of mass production, which is in fact pretty useless. Now, why is it that the Europeans got it and the United States didn't? Well, from what I can work out, it's because the US was more organised. Its processes were superior. And just as an outsider, an Aussie with no interest in it whatsoever, I got to say it was way easier for me to find out what the Americans were thinking and why they were thinking it than to find out what was happening in Europe and why. And the other thing is that the United States had some really important user group institutions that were tapped into Congress as a matter of practice and reality. You've got an Academy of Sciences, which has been in existence for 143 years. The EU has a Science Council, which has been in existence for 13 months, 3 days and 4 hours by my calculations, although I'm not so sure about the 4 hours. And what happened was that you had business which was organised, because business organises quickly when there's money involved, and the Federation of European Publishers had their act together in terms of the lobbying. But the users did not exist in a pan-European Union way. And in some ways, we need to remember that the EU, as opposed to Europe, is very young. It's only been around for 40 years or so. And it simply did not have the relevant institutions to respond to, deal with, and indeed oppose what was a bad idea. And so it's terribly important that we think about our social capital, our institutions and our processes, and ensure that they have the opportunity to have input into these sorts of decisions. Because if the US had got it as wrong as the EU had got it wrong, the whole world would now have a useless weapon of mass production. Thanks.
Thank you very much, Professor Davison. I'm now extremely pleased to be able to introduce Professor Marshal Leifer, who is a distinguished scholar in intellectual property law at the Indiana Law School in Bloomington, Illinois. Indiana, why do I say Illinois? I do this at every conference, I'm sorry. I introduced Jessica Littman as being in some completely different state as well 2 years ago, so I know I'm going to do it at one conference or other. Professor Leifer was formerly at the University of Toledo College of Law. He is a prolific scholar, particularly in the area of copyright law. Pretty much every article I've written in the last 5 years, every second footnote refers to his work. He has been an attorney in both the US Patent and Trademark Office and the US Copyright Office. He is an international speaker on a lot of these IP issues, and it gives me great pleasure to turn it over to him.
Oh, thank you, Jacqueline. It's a real pleasure to be here in this really interesting conference, and I was fascinated to read Mark Davidson's paper and hear his talk on the database issue, and it leads me to a I don't know, maybe an adage. Maybe in this conference we'd call it a punchline. When the legislature is in session, the life, liberty, and property of its citizens are not safe. Anyway, I think that some of this has been borne out by the kinds of projects that the various legislatures have been engaged in. I was hoping to be able to criticize Mark Davidson's position, but unfortunately he was, I guess, preaching to the choir as far as that was concerned. I do think, obviously, there is a free riding issue when you're dealing with databases, and I think that in some instances, creators and database owners are unable to recoup their investments. But I couldn't agree with him more that the cost of a sui generis database law outweighs its benefits. He very nicely showed how the U.S. came so close down that path to passing a database law legislation. For the moment, it does seem like a bit of dead issue, but I think it'll raise its head maybe in the future. I hope they will take some sort of well, certainly be informed by the European experience and the European report that gave us sort of a jaundiced view on the efficacy of database protection. Unfortunately for Europe, it seems as if it's a fait accompli, and I guess there's another adage that goes that the bad laws, once they're on the books, are hard to get rid of. It's always been a justification for passing new intellectual property laws. I've heard this a million times. There's a gap in protection. It's the gap metaphor. And it's used to justify any kind of legislation, and of course the implicit assumption here is that airtight legislation in the intellectual property field this is what we are striving for. We want to have a complete airtight protection of all kinds of informational goods. The world shouldn't be that tidy a place. And I think that there's a need to have a flexibility in systems. I think there needs to be a certain kind of ambiguity in which courts can develop reasoned rules and also adapt to new technological situations, for example. But for the moment, I think that the database question or the database law is a kind of a dead issue in the United States. But I just want to add one more thing. I think that even though the Europeans might say, well, it's an inoffensive law, there's no such thing. Again, another adage of an inoffensive law. You know, all laws impose prices on people's behavior, and if you don't behave in a certain way, you got to pay it. You got to pay the price. So there's no such thing. And so anyway, the problem, as I see it, is this striving for the cumulative protection. Now, maybe if we're going to do the world over again, what we would have is we just take databases, and for that matter, I'd like to take computer software and a lot of other things outside of copyright. Just get it out of copyright, have the sui generis kind of provision or regime for it, and that would be fine. It's too late for that. And secondly, when you're talking about compilations of fact, which is the basic subject here, the Berne Convention, Article 2.5 says that you got to protect compilations as to the selection or arrangement, but not necessarily as to their miscellaneous facts. So we have to protect compilations of facts, these very problematical works, and they're problematical because anytime you have a work which you could call a functional work, a work of utility of some form, it causes copyright problems. But there's a tension there. It bumps up against the essence of copyright. Well, let's take a look, though, at the latest iteration, however, of the database law. And I'm sorry, I would have had this on the board, but for reasons beyond my control, I don't have it up there. But I want you to just think to yourselves: is this the kind of is this necessary? Is this a good law? Incidentally, the latest iteration of the database law was one that was the most congenial to the scientific and educational community, which at one time was at the forefront in opposing the database law. The latest was 3261, and it's based on a kind of a misappropriation principle. The database was generated through a substantial expenditure, that the taking occurred in time-sensitive manner, inflicting energy, and that the ability of others to free ride in the efforts of the plaintiff would reduce incentive to produce the product. It wouldn't apply to nonprofit educational, scientific, and research institutions, provided a court determines that the activity is reasonable. And there's a counterpart part in this that sets up a database misappropriation as an unfair method of competition under Section 5 of the FTC. So you can say to yourself, well, this sounds pretty inoffensive. Why might not do it? And indeed, I mean, a lot of people in the educational and scientific community says, well, listen, if we're going to have one, let's have this one and not those other things that first came down the pipe, which are much more kind of property-oriented rather than this kind of misappropriation, time-sensitive oriented. Well, what happened here, of course, is copyright is politics by other means, and the database community or the provider community says, wait a minute, I mean, what is this time-sensitive stuff here? We want to just protect our databases, and so here you go on and on and on. Well, anyway, my general position here today, and I just can only do this as a very kind of a quick overview, is that database owners really have nothing to fear. As a matter of fact, Alain posed a question: is copyright too strong or too weak? Well, at least in the United States situation, when you're talking about copyright protection of databases, I think it's flourishing. I think it's doing quite well. I don't think there's anything here that really would cause is a cause for that much alarm. There are a million ways that database owners can enforce their rights under all forms of law. I mean, you have the Computer Fraud and Abuse Act, for instance. I mean, this is you could point to that. I mean, it prohibits certain access to computers without authorization, imposes substantial civil and criminal liability to anyone knowingly with intent to fraud accesses a protected computer without authorization. No, I mean, I can go on and read the law. You have state law remedies, which are very serious things. The contract remedy is not small potatoes, and it's caught on. And I think the database owners look to that in a very serious way. I know, of course, is not the privity problem and all of that, but come on, Pro CD versus Zeidenberg is really winning the day. It's the court found that a contractual restriction and a shrink-wrap license to be enforceable and not preempted by copyright. And now there are other dissenting voices and a few mutterings in other circuits. But when you look at the CAFC, in the Bowers case, when you look at 11th Circuit cases, that Pro CD is winning the day. I mean, the database owners should be happy about this and should be rejoicing. What are these glum faces, This trespass to property that's developed in the state courts. There's the eBay case where, the defendant had used automatic robots to query eBay's website about 100,000 times a day to collect information about online auctions, and a preliminary injunction was issued there on this trespass to property. Well, then, Mark also mentioned the misappropriation doctrine, which, has a kind of a checkered career, to say the least, and but it's still conceivably available. I wouldn't say that is a serious remedy, but it's still, you find some recent cases like the Polestar case that have used misappropriation to protect a database under state law. And then there's protection outside of the law of within the law of copyright. I would call it, some would call it a kind of a quasi-copyright or para-copyright. I mean, it's protection by the DMCA, a very substantial protection by the DMCA that database owners certainly can use with quite easily. And then, of course, I mean, they're just self-help technological measures outside of copyright completely. Don't feel sorry for database owners. They're doing okay, and I think that we shouldn't be too upset about this. What has happened since the Feist case? I mean, is there any way that we can talk about database under copyright law? Because actually, my final remarks deal with the Feist case and the criticism of Feist, which would lead others to believe that we need a sui generis law to fill those gaps. Now, the 1991 Feist case, of course, says that compilations had to exhibit sufficient creativity in their selection, coordination, or arrangement to be protected under copyright. And of course, this would presumably exclude things like the white pages in the Feist case, which didn't manifest that creativity, that modicum of creativity in selection and arrangement of the data. And so this was the moment where the house was supposed to fall down. The Feist case also went on to say that database owners, I don't think it really said this, but it sort of said this. It said database owners don't feel too bad. The threshold is very, very low. It's there. We should be able to quantify it, but it's low. We're not asking for too much, but just a little something. And so take a look how the law has developed. The first thing was that people were really worried. Well, if the white pages are going, then the yellow pages were going, and that's not true. And in the key publications case dealing with the Chinese American business pages, and in the CCC Information Services case, I think that this is a landmark provision. This is a cause for joy among database owners because in that case the court found creativity, the modicum of creativity or originality, and the selection of used car prices. Used car prices. Now, why is that? Well, the court makes a distinction between hard facts and soft facts. Hard facts being, I guess, when did the sun rise today at 8:15 or whatever. But soft facts are the kinds of facts that are infused with the taste and judgment of the compiler. And they said, well, these used car prices don't come from heaven. These car prices are really the kinds of things that are made up. So don't take them too seriously, I guess, is what we're saying. But that was the soft facts notion. And I think that when you take a look at cases like this, you see that the standard is rather very, very thin. Now, there are problems in the law, and I think the major doctrinal problem, at least for the database owners, which we really haven't worked out yet, and I think this is really the open question, does deal with electronic databases. We haven't really tailored the law in a proper kind of way to take into account a kind of a technical problem here. A lot of times databases, of course, their value lie in their comprehensiveness rather than in their original selection. And then the second thing about databases is that one of the advantages, certainly, of electronic databases is that they're designed to be accessed by software that allows the user to choose from many different possible arrangements. Thus, the selecting and arranging the information in a database that is sufficiently creative to qualify for copyright protection may detract from the usefulness of many databases. This is the kind of the database paradox. Now, I see it as a problem. But again, is there a benefit to passing a sui generis type of provision, particularly to take into account this kind of seeming gap in protection? Maybe, and I would like to hear what your thoughts were, how you might tailor the doctrinal strictures of the law in perhaps to address a certain kind of true problem that might, in some instances, jeopardize or discourage the creation of certain forms of databases. Well, anyway, there are limits to databases still, and I will end in briefly in two cases. I have 1 minute, but I about read about the end. Okay, I'm going to see the big sign. There are some absurd cases that a database owner would have loved to have had. For instance, in the Dorothy Parker case, a 2005 case, protection was denied to a professor who had gathered 22 unpublished poems of Dorothy Parker. And he wanted, the selection and arrangement copyright on them. He arranged them according to chronologically, and he spent a lot of time and effort, getting these things and getting them together. But the court said that this is just not going to make it. The thing about it is, though, that you can agree with this case, but it was appealed all the way up to the Second Circuit, and there was a lot of, kind of a serious opinion written about this. This really shows you that database owners are not doing bad, even when they're limited like this. That's what, to me, I think database owners should applaud this kind of thing. And then finally, a more serious approach is in the Wire data case, in which a firm, by means of contracts with a state agency, tied up a lot of information about real estate prices and the like, and so the state agency has an open records law, but a competitor, well, it wasn't really a competitor, but a third party who wanted to use this data tried to get access to it, and the state agency said no, because we have a copyright exception here. And so what happened is that Richard Posner in the Seventh Circuit looked at this and said, yeah, perhaps the compilation here is protectable under under the selection and arrangement, because the selection and arrangement did have categories and that would meet the criteria. But he said it would be a tragic thing to allow this to happen, to disallow access to this kind of information, to deprive the public of it, and this would be, I think, a seriously competitive harm and an overreaching by the database purported database owner. He said that that there was a fair use here, simply a fair use to use this the information. And secondly, he said that, you know, if the plaintiff actually here tried to assert his contractual arrangements with the state, that this might be a form of copyright misuse. So, you know, I think that the database, to sum up, is flourishing. I think that for anything, there needs to be some limits on even the extent to which we have gone under this so-called flawed kind of Feist law itself.
Thank you very much. I think you're actually right about what the court said in Feist, other than the don't worry database producers section. Our final speaker for the panel and for the day is Guido Westcamp, who is a senior lecturer in IP law at the Queen Mary Intellectual Property Research Institute in London. He is an expert on both German and British law, having various law degrees from both Münster in Germany and also Queen Mary in London. He has degrees in intellectual property and English law. He is also the director of the University of London LLM course entitled Intellectual Property in the Digital Millennium. He has an incredibly large and eclectic range of research interests, which are listed in the papers for today. And without any further ado, I'll turn it over to you.
Right. Thanks very much, first of all, for inviting me. I will make it very brief because a lot of the issues that Mark and Marshal have already addressed. I'm going to focus on three issues in relation to the European Database Directive. The first of which is, how did it come to be an intellectual property right, or if you like, an exclusive right? And I'll then look at the problems in assessing what infringement is and what the response in various European jurisdictions was, and also the recent ECJ decision. And then I'll look at the impact of the Information Society Directive on databases. Now, first of all, why has the entire, if you like, debate focused so much on the protection of databases under intellectual property law? Looking at the prehistory of the European Database Directive, what you can see is that it is based upon 5 role models. We had British copyright law that would protect skill and labor in a compilation. We had Scandinavian catalogue rule, which was some kind of right proximate to copyright law, something similar in the Netherlands. And we had unfair competition in most other European jurisdictions. We, of course, had also copyright protection. Now, one of the major obstacles for harmonization was, of course, the gap in protection between the UK system and particularly the German system. The German Federal Court of Justice maintained a view that in relation to functional works, informational works, organized works, the author would have had to show that there is a striking distance from average works. So the level of creativity that was required was extremely high. And of course, on the other hand, you had the UK system, sweat of the brow system, where some skill and labor would be sufficient to get copyright protection. So one of the reasons why this turned out to be an intellectual property right, or kind of neighboring right, whatever you want to call it, is of course that the UK system and the continental, the author's right systems had to be harmonized. Looking at the development of the directive, another interesting feature is that the initial proposal from 1993 didn't talk about an exclusive right. It talked about an unfair extraction right. It was only in the final draft that the words an exclusive right to authorize or prohibit reutilization or extraction appeared. The reason, again, being the UK position. It would have been extremely difficult, of course, to change or adapt UK copyright law so as to have an increased level of creativity in copyright for functional works, plus some kind of unfair competition approach in addition to that. The UK, of course, doesn't recognize a general unfair competition approach. So again, the final decision that was taken was to say, okay, what we do is we create some kind of exclusive right. The UK will increase copyright protection and will introduce the sui generis right as it is, and everybody will be happy. Perhaps a final motivation for the European lawmaker to enact something that may be called intellectual property right is, of course, the fact that the Database Directive contains a reciprocity clause that would only give sui generis protection to foreign database makers if the same level of protection was granted to European database makers. I guess that the background to this is the Semiconductor Chip Protection Act in the United States, which did exactly this to European semiconductor chip producers, which additionally had the apparent advantage that the unfair competition approach would have to be taken out of the Paris Convention and the reciprocity requirements under Article 10 bis. So that in the end, the European Commission thought, right, what we can do is we can invent some kind of new exclusive right that is sui generis, that is not affected by any international treaty, and that we can successfully export to other countries. As far as I'm aware, the European Commission was successful in exporting it. There is one treaty between the European Union and the Isle of Man, which now requires the Isle of Man to protect database makers under the sui generis right. And there were also negotiations with, I think, Singapore. Everything else has failed, including, most notably, the United States. So the question really is it an intellectual property right? Should it be an intellectual property right? What does it protect? The Database Directive doesn't say what it really wishes to protect. And courts have been struggling with that notion. What you may infer from the text of the directive is what is protected may be a database, as defined in, I think, Article 1. Collection of information that is individually accessible, etc. Or it may be the contents of that database. That is to say, some kind of information, or indeed it may be the investment that has been expanded into a particular collection, compilation, database. The early case law from Europe shows that courts have had very severe problems in defining what the object of protection should be and how that object of protection then will inform the assessment of infringement, that is to say, the assessment of what the substantial part should be. The role model for database protection was, of course, the gap in Feist, which is, I think, a rather straightforward case where you need maybe some kind of protection in whatever form because you have very, very high costs in producing that type of compilation, but very, very low costs in simply compiling or electronically copying that collection, and then, of course, putting it on the market as a competing product. The early case law shows something entirely different. This type of case hasn't occurred so far. What we found, especially in lower courts in various European jurisdictions, were cases that concerned, for instance, the taking of information from websites, information that as such was then qualified as being insubstantial, but the act of taking or extraction, reutilization, was repeated and systematic, and therefore would have constituted an infringement of Article 7.2 and Article 7.5. So most of the early cases that we've seen have simply looked at the Database Directive and the sui generis right, and concluded that, well, we have a database because a website is a database. We have some extraction because if you copy, that is an extraction, and necessarily if you make temporary copies, that is within the ambit of protection. Is it substantial? Has there been substantial investment? In the academic debate, you find anything from threshold shouldn't be too high to it should be extremely high. So courts would say, yeah, you know, that is a substantial investment because some money has gone into making that particular connection. Is the extraction or reutilization substantial? That depends on the quality or quantity. What is quality? Quality is the ability to sell a particular piece of information. That's what Justice Ledier said in the United Kingdom. That is to say, if you have something, and I think Mark already pointed that out, if you have something where you have a potential demand commercially, then this might qualify some piece of information as qualitatively substantial, and under the text of the directive, this is sufficient for infringement, because the quality and quantity test is alternative. It's quality or quantity, not quality and quantity. And necessarily, if you look at the quantity test, you have a big problem because what it says is you look at the database as it is. You do not look at the investment. And therefore, what courts need to do is to apply some random proportionality tests and come up with maybe a formula that says 40% will always be a quantitatively substantial taking. And of course, that test doesn't work, where you simply look at, you have a database and you have some extraction, and then you look at the value of the information or some random arbitrary percentage that has been taken. So the question is, can it be an intellectual property right? My answer would be, no, it can't. If it protects the investment, you will necessarily have to look at an infringement or a violation of that investment. And then I think that the US proposals and approaches and the way in which the European directive is interpreted are far more proximate than it would originally appear. If investment is the object of protection and that investment must be substantial, the substantial taking must refer to the investment rather than to the contents. And this is also made clear in the recitals where it says what is protected is the investment. It's not the contents, which is in the articles. And then, of course, if you protect investment, where do you protect it? On a market. So what you protect in the end is a certain commercial position that has been acquired on the basis of some kind of substantial investment. That is in line, I think, with the UK approach in copyright, with various approaches under unfair competition law or misappropriation law in the United States and other Commonwealth jurisdictions. So that in the end, what you have is a rather flexible test where you can take into account, indeed, the consequences of taking some information on the initial market and then pose the question what that initial market should be. And you can then pose further questions whether that market should only be the actual market or whether it could be a reserved market, etc. So the test would be flexible. But be that as it may, one thing that has gone largely unnoticed under the Information Society Directive is that all European jurisdictions now protect the database sui generis right under the DRM provisions. And this is particularly worrying because the right in databases is only qualified by the fact that you would only grant protection in relation to a substantial part. So the insubstantial part is, by definition, not part of protection. Of course, if you apply technological protection measures, then you necessarily protect those insubstantial parts as well. And even, although most European jurisdictions whilst transposing the Information Society Directive, have taken the view that there must be a copyright nexus. You easily have that copyright nexus because access to or use of insubstantial database contents requires the making of transient copies, and Article 5.1 of the Information Society Directive, which exempts certain transient copies, maybe also copies made in RAM, doesn't apply, again, arguably to databases, because the protection under the Information Society Directive is distinct from the protection granted under the Database Directive. The only European jurisdiction that has, I think, seen that there is a problem with database protection and TPM protection is indeed Spain. Spain has implemented the Information Society Directive a couple of weeks ago, and it's the only European jurisdiction, as far as I can see, that has inserted the limitations on research in relation to databases into the list of limitations under Article 6.4. Finally, another contradiction that is going to appear. The Database Directive protects lawful users against certain contractual clauses which prohibit the use of insubstantial parts. Again, this will potentially create huge problems in relation to the use of TPMs, because the question then is how can you protect your contractual position against the use of TPMs? So apparently, I think, even if you could adapt the seemingly very rigid protection granted to databases and make it more proximate to some kind of unfair competition protection, this is very much called into question by the additional protection that is granted under TPMs under current European legislation. Thank you.
We have about 10 minutes left for Q&A. If people have questions, I don't know if we have microphones. We have microphones. Are there any questions, comments? There are, actually, there's one up there and a bunch down.
My question's not directed at anyone in particular, but I guess to the group as a whole. In June 2004, WIPO decided that the Database Treaty would not be on every single agenda for the Standing Committee on Copyright, but the standing decision is that it shows up on every second meeting agenda. So for those of us who regularly attend WIPO meetings, this has been a source of some concern. I'm wondering, given the report that's now come out reviewing the European Commission report that's reviewed the success or lack of success of the 96 Directive, whether you have any views about whether it might now disappear as an item on the agenda, or whether there are forces beyond the European community who might want to see this continue at the international level.
Well, I guess a dignified response would be to quietly remove it from the agenda. I mean, I really don't see how the EC could possibly suggest that the world should take this on after its own report said it looks as if there's no evidence for the value of this whatsoever. So then, I don't think that the NGOs would have the capacity to say this should be on the agenda, as I understand the processes, but I may be wrong. You know, the least they could do is wave the white flag, I would have thought.
Is it possible that there are other forces beyond the European community who might find country support beyond the European community for keeping it on the WIPO agenda? I guess that would be the other dignified way of not necessarily having the NGO forces do it, but having NGOs build a coalition with other countries. Do you see any evidence that this would be something beyond the European Commission who might want to see such a right?
There were regional meetings of WIPO, when was it, 2001, 2002, I think, And there were a number of countries that said, yeah, this is a good idea, but most of them, I think, were saying it was a good idea because they wanted to be part of the EU. And unless the pressure's coming from the EU, I can't see the pressure coming from any other national group. And the other issue is that if the US says, you're kidding, well, why would you waste your breath unless it's an excuse to hang around for another day and have a few more gin and tonics? But I would have thought it'd be a waste of time. Yeah.
This question, I think one sub-theme that we haven't considered is the process in developing countries, certainly with traditional knowledge databases, and what is appearing to be a hook into the database discussions in WIPO to try to link traditional knowledge, biogenetic resources, and database protection. And that raises all kinds of tensions that we don't have the time to go get into, but something we should keep at the back of our minds is likely to resurge and to revitalize prospects for some sort of international movement for databases.
Yes.
And geographical indications.
Yeah, and geographical indications.
Europe is pushing its agenda.
A short comment on the fascinating presentation of Mark. I completely agree with your analysis. With the conclusion, a little bit less. I agree it's a useless system, but maybe not for continental countries having only an unfair competition system, and that's quite a few countries. I still think that it makes a little bit of difference to have to sui generis right, because when you have to sue on the basis of a tort and to prove the prejudice, like it is the case in most countries having an unfair competition system, it makes a difference than to sue on the basis of a property right. And the other difference, I think, is for licensing. It's easier, I think, to do some licensing when you have an IP right rather than some unfair competition system. I don't know whether you have found, and that's a question for the other person of the panel eventually, that there has been some impact on licensing because you have some easiness to draft contracts when you have the sui generis right in Europe.
Yeah, look, I'd agree with those general propositions. I guess it's a question of cost-benefit. I don't think the cost of the directive justifies that benefit that you did identify. And yeah, you're right that it is a far stronger right than unfair competition, and I didn't intend to say that if that's how it came across when I referred to that French case. But I guess I'd reiterate what Marshal said, and that's really that if a database owner can't find a way of protecting their database, they really need to sack their attorney. You're just not trying. And if you're not trying, why should we give you a database, right? Just, as he pointed out, there are just so many ways in which you can do it that if you don't know how to do it, well, I guess it's not that important to you.
Yeah, maybe one word. I agree. It's maintaining an IP right, especially for authors' rights systems and countries where you have problems with unfair competition law because of the constant interface between IP and unfair competition. Makes it easier to license rights, and I think it's right now, especially in the area of biotechnology, that you would normally license database rights. The problem that I was talking about really has more to do with the question of how do you assess what the scope of the right should be, and should it really work like a right there? Basically, when you just look at what's the content and what has been taken. But I agree that an initial, if you like, qualification as an IP right doesn't do any harm, and if that facilitates licensing, then that should be the case. And I think it's especially important if you look at cross-licensing issues, cross-border licensing, where you may have different applicable laws. So there you have some kind of harmonization.
We have time for one more question.
Actually, the question is, what should the EU do now that the Database Directive reports come out? You could, because there's one little other piece of the puzzle, which of course is because the copyright, there was another part of the bargain, particularly for the Brits, which was the harmonisation upwards of the level of originality. All right, so if you simply took away the database directive, that would mean the net result of the whole process would have been to simply harmonise the copyright originality standard, which the British and the Danes and the Nordic countries might not actually have agreed if that was the only part of the deal. So it's an interesting whether you unravel the whole package or simply repeal the database directive. And the other comment very quickly was a few weeks ago at a conference we had in Chicago, and Jerry Reichman and Jane Ginsburg both made the same observation that the primary argument now for a multilateral database treaty would in fact be to constrict rights that are available under national law under all the systems that Marshall talked about, most notably contracts. So that's an interesting example of where multilateralism might actually think about coming in fact, to provide a very defined right that may be good or bad, but a lot better than the stuff that's existing in national law.
As for what to do, Europe's in a very hard position. I can't imagine that they can repeal it. I think too many people have engaged in the licensing that Alain just talked about, and to unilaterally take away that intellectual property right now, it's just too hard. What should they do? I'd love it if they did it, but that's just my, nasty, mean, gremlin-like attitude. But they can't, and they won't. I think they're stuck with it. I don't think they can amend it either up or down. I think they're just stuck with keeping on going back to the ECJ to have arguments about things. Serves them right, frankly. That's about all I'm saying.
Did you want to add to that?
I would just say, if it's national law, we try and yank it back, it would be, raise all kinds of concerns like expropriation and, constitutional concerns. So I don't think there's any way forward to repeal it or to make it go away. So, but I think that's the future. We'll go to the ECJ.
Well, on that depressing note about the future of database protection, I have two quick things I want to say before I thank the speakers. The first is to remind you that there's a reception around behind us in the foyer with food and drink, and please feel free to stay around and talk to the speakers further. The second is just a personal comment. I wanted to say, as I said to David Weber during an earlier break, that I've been a little selfish with this symposium because organising this has been my excuse to gather together all the people I most like to hear from on all the topics I most like listening to comments on. So I hope you have all enjoyed it as much as I have. And with that, I'd like to thank these speakers and indeed all of the speakers who came today.